reading. Yes, Mr. Pal. Any other matter? I will not take now. I will not take. I will not take.
No, my lord.
My first contention is that, my lord, my first contention regarding the maintainability of this 227.
Please carry on. एखानकार माने लॉयर लोग का कोई माने 100 बार बोले उन लोग का कोई डिसिप्लिन ही नहीं है. Yes, you please.
My lord.
One second, Mr. Paul. ये केस मेरे ऑर्डर लिख दीजिए तो. आपने रिकॉर्डेड. Because from today तो I cannot pass order. Okay, then which matter? 11, 12. 12. What is the number of your case?
Item number 12, CO number 664.
12. রানিং তো করছি ওনা দেখে দিয়ে ছেড়ে দি ও লাগবে না দেখতে লাগবে না such and such মানে
566 of 2021.
Today has been fixed for filing this thing. Order was already for filing documents. That's why. Okay. Who is the lawyer for the opposite parties? Okay. Parties are represented by their respective lawyers. The record shows you are the opposite party of petitioner. Petitioner have already filed documents that has been called for. The order is not ready. Let the record be placed on 11th of March for passing order. Is there any interim order? No. 11th of March for passing order. Yes. Huh? Item number 12. Yes. अभी किचु करबो ना 11 बोली दिन.
My lord, my submission would be very limited, my lord.
You said maintainable because there is an alternative remedies available. Yes, you
my lord, I'm submitting, my lord. My first primary contention is that the 227 is not maintainable regarding in respect to any judgment, especially where there is an alternative remedy. My lord, I am coming. First of all, my lord, I will show my judgment. I will deal with the judgments of the petitioner. Thereafter, I would try to satisfy your lordship that petitioner is a consumer.
Mr. Lawyer, you please cut short your submission because it's already 1 o'clock. I'm not bound to hear you after 1 o'clock.
My lord, can it be taken at 2 o'clock, my lord?
I am giving you this thing. I'm giving the hearing because I believe today there is a resolution. There is a resolution in Bath. That's why I'm giving you this thing, special work.
So, my lord, since we are appearing, my lord, on consent we are appearing, my lord. Perhaps.
You please make submission. You please do not elaborate and do not. I will go through the.
What is only 5 to 10 minutes, my lord?
It is not maintainable in under Article 227 Constitution as because there is another alternative remedy. Yes, you please.
Not only that. Yes. Not only that. I will try to satisfy my lord that the opposite party is a consumer. Then it is my belief that my lord will not entertain this.
Yes.
Employee
can be a consumer. Now employee can be a consumer provided do you pay for the things
my lord,
electricity supplied
to you. Thing, my lord rightly pointed out, I paid, my lord, for the service. Why when I am going, my lord? Kindly, my lord, give me some time. My lord, first of all, my lord, there is alternative, as I said, the alternative remedy is not an absolute bar. My lord, kindly come to, first of all, section 19 of the Act 1986. Section 19, my lord.
আপনি আসলে আমি করতে শুনতে পারবো না আপনাকে সেকশন 19 আপনি টাইম ওয়েস্ট করবেন না আপনি দাঁড়িয়ে because it's already 1 o'clock. I'm not bound to hear you because my office time is over and 2 o'clock there is a specially fixed matter is there.
My lord, section 19
फिर भी आप लोग satisfied नहीं होता है आप लोग को जितना भी हेल्प करते हैं satisfied नहीं होते appeal lies. Yes,
my lord, section 19 says about the appeal. My lord, no, the scope of appeal or appellate authority is more wider than the revision, because in appellate authority can reapprise the evidences, question of fact as well law. My lord, here the section 19 says any person aggrieved by an order made by the state commission. My lord, here the order of the state commission has been upheld. a person agrees by an order made by the State Commission in exercise of its powers conferred by subsection 1 of clause A of 17 may prefer an appeal against such order to the National Commission within a period of 30 days. So, my lord, there is efficacious and alternative remedy of appeal where the petitioner can get more wider chance, because in 227 court cannot reappraise the evidences, question of fact, but question of law only. Now, my lord, I request my lord to come 21, section 21B. So, what I am relying on going, that is the category. When a legislature enacts an enactment with some object, that has to be followed first. So, if we not follow, then there is no meaning of legislature and other organ. My lord, 21B. 21B, national, it says about the National Commission to call for the record and pass appropriate order in consumer dispute which is pending before or has been decided by any state commission. That is, I think, enough. That means, my lord, under 21B, the National Commission has the same power which my lord is entertaining in respect to this petition. So, this point also can be asked under 21B before the National Commission. Now, my lord, I showed, my lord, the efficacious alternative remedy which is prescribed by the legislature. Some object, when enacting this enactment, it is a beneficial legislature, my lord. Changing all the aspects, this provision has been made. Then that cannot be bypassed. Then we go above the list. My lord, there, my lord can find in your my lord file, some bunch of your judgments, my lord. There are 5 judgments. I already supplied to my lord.
Yes.
My lord, kindly find, my lord, 2011 1 WBLR.
Get page number.
My lord, actually, that judgment has been supplied by pinning up the bunch, my lord. Kindly, my lord, judgment name is Sri Probir Day. It is single page judgment. 2011. My lord, find it.
आप लोग ना, हम इतना आप लोग को सुनने में बहुत खराब लगते हैं. आफ्टर कमिंग वर्किंग इन द लॉ कोर्ट ना, ये सब हम लोग नहीं देखते. ये सब यहाँ पे आइए, ये खोलिए, आइए, ये सब जजमेंट खोलिए, ये जजमेंट खोलकर दे दीजिए, सब जजमेंट खोलकर दे दीजिए. जजमेंट क्यों बांध दिया, वो जजमेंट खोलकर दे दो. रिकॉर्डिंग
there are a bunch of 5 judgments
which I
have already supplied.
What is the name of the case?
Name is, my lord, Sri Probir Day, 2011 WBLR. Probir Day.
Kindly give the page number.
2011.
261.
2011.
2011 volume 1 WBLR West Bengal Law Reporter, Cal 261 page.
Yes, please read the thing. Relevant paragraph.
Probir Day.
Paragraph.
My lord, paragraph, my lord, I am relying, my lord, I am relying, my lord, paragraph 3-4. This is short judgment, my lord. This is 6 paragraph judgment. This is the judgment. It is the judgment of the our senior most judge of his lordship then was. Well, I am reading paragraph 2. This is the same, based on the same fact. The consumer order of the consumer state commission has been appealed here. The same fact. My lord, paragraph 2 I am reading. The propriety of the paid order was thought to be challenged by the petitioner before this court in this application under 227 of the Constitution of India. Same fact, based on similar fact. Paragraph 3, my lord, I am reading. My lord got the judgment, my lord.
Yes.
Paragraph 3, Mr. Banerjee, learned advocate appearing for the opposite party, raises a preliminary objection regarding the maintainability of this application, that of this not mean 227 application, on the ground that the order impugned being appealable, section 19, my lord, kindly remind me, under the Consumer Protection Act, the instant application cannot be entertained by this court. As a matter of fact, 21B, my lord, I have just shown. as a matter of fact, 21B provides for revisional power to be exercised by the National Commission. Since an alternative remedy is available under the statute that is enacted by the legislature, this court refuses to entertain this revisional application before this court. That is one, my lord. Next judgment, my lord. I am showing judgment name is Nurul Huda Lai. That is, my lord, 2011, volume 1, Pt-1, Calcutta, page 665.
I didn't get the reference. Kindly repeat. Kindly.
Yes, definitely. 2011, volume 1, Pt-1, page 665.
Yes.
It is our Calcutta High Court judgment. The judgment was passed by the then Chief Justice of this court, my lord. Now, my lord, I first read the paragraph 1. What is the fact? This fact is also similar of the fact of this present case. This application under, my lord, paragraph 1 I am reading. To show the fact is similar. This application under 227 of the Constitution of India is directed against an order that is certain such passed by the State Consumer Dispute Redressal Commission in RP number certain such, setting aside the order of the stated certain such of the District Consumer Forum. That means for a similar fact. So the order of the State Commission has been upheld of. Now, my lord, I want to rely paragraph 10. Paragraph 10 of the judgment. If my lord, I am reading. May I? A preliminary objection regarding maintainability of this application under 227 of the Constitution of India was raised by Mr. Chatterjee, the learned advocate, appearing for the opposite party, who contended that in view of the provision contained in section 21, that means 21B, power of revision of the national, 21 of the Consumer Protection Act, the impugned order means the order of the State Commission, there. The impugned order being appealable, section 19, appealable before the National Commission. The application under 227 of the Constitution of India is not entertainable by this court. By referring to the decision, certain such, my lord, Shalini Shyam Shetty, that will also I refer, my learned brother also refer. Then, my lord, kindly come to 14. That is the observation of this court. It is rightly pointed out by Mr. Chatterjee then the order which is impugned in this revisional application is appealable under my lord 19 before the National Commission and 21A2 of the State Act, that is revisional power. As such, the petitioner hearing is not remediless. My lord, kindly consider this. As a matter of fact, the scope of appeal is much more wider than the superintendent power jurisdiction of the High Court. My lord, that also kindly record what I said earlier, my lord, while showing section 19. So, under 227 of the Constitution, even the
2011
দাদা একটু মাইকটা মিউট করে রাখুন। Even the justification for non-appearance can be much more effective projected before the National Commission in the appeal. Why this court has said? Because, my lord, if there is any objection regarding facts or evidences, the petitioner can argue there. On the contrary, this court, sorry, my lord. On the contrary, this court sitting in this jurisdiction under 227 of the Constitution of India cannot convert itself, my lord, kindly note, cannot convert itself into a court of original jurisdiction that has been provided by the statute itself. For ascertaining the sufficiency of reason for non-appearance of the petitioner before the learned State Commission. So here the cause was the petitioner was absent. That's what I want to exactly point out, my lord. The 227 court cannot convert it as a court of original jurisdiction, what the National Commission is enjoying under the statutory provision. Now, my lord, of this judgment kindly come, my lord, of this judgment kindly come paragraph 16. There is also observation part, my lord.
দিদিমণি আপনি চলে যান, খেতে যান, যেতে চান তো খেতে যান। Yes,
I know my lord is taking so much pain for me. My lord, kindly bear me, my lord.
Yes, 16.
16. What the court said, that apart, this court, this honorable court, cannot be unmindful of the principles laid down by the honorable Supreme Court in the above mentioned decision on the question regarding the exercise of High Court jurisdiction under 227 of the Constitution of India. In fact, the following principles were formulated by the honorable Supreme Court as to where and when such jurisdiction can be exercised by the High Court. The judgment is referring here, that is the judgment Shalini Shyam Shetty, the judgment which have been relied upon by my senior, and also I also rely upon it. 16, paragraph 16C, kindly come. The High Court cannot, on the drop of hat, in exercise of its power of superintendent under Article 227 of the Constitution, interfere with the orders of tribunal or court inferior to it, nor can it, in exercise of this power of superintendent under 227, act as a court of appeal over the order of the court or tribunal. Their tribunal is state commission, subordinate to it. In cases where an alternative statutory mode of redressal has been provided, that would be operate as a restraint on the exercise of this power by High Court. Kindly note down, my lord. I also rely on 16A. I am not submitting, but kindly note down, my lord.
16?
16A.
Yes.
Just page 670. I'm not reading it, but my lord, kindly note it.
Yes, yes.
My lord, may I go to next judgment?
Yes.
Yes. Now, my lord,
এটা রেফারেন্স একটু বলবেন।
হ্যাঁ দাদা, আমার দাওয়াত ইমেলে পড়া আছে, এটা রেফারেন্স হচ্ছে 2011-1 Pt-1 665 নুরুল হুদা লায়েক। আমার দাওয়াত ইমেলে আপনার অ্যাডভোকেট রেকর্ড। Then, my lord, next judgment, which is the very important judgment. Why I am saying it is very important? Because we know that 227 is a constitutional power of the High Court. But my lord, this judgment has been passed under Article 141 of the Constitution of India. That is the, my lord, an power. It is also a constitutional mandate therein, which 141 says. I am coming later on. My lord, kindly take judgment Sicily Kerala. I am referring the citation 2012, volume 8, SCC, page 524.
You have made elaborated decision on this matter. I have already noted down also, I think so.
Yeah, my lord, it is first time I am, my lord, submitting, my lord, showing, my lord. This is a very important judgment, and this judgment is why very important, because this is presented governing the question regarding the issue which we are discussing. So I am going to the judgment, my lord.
That is
My lord, kindly come paragraph 4. Paragraph 4.
the case number is 2010.
2012 Supreme Court cases.
2000.
Page 5, 2012. Page A, volume A.
Yes.
My lord, judgment name is Sicily Kerala versus Vehicle Factory. It is a judgment passed by the Honorable Supreme Court. Here, my lord, what happened? The order of the State Commission has been upheld under 223. Now, my lord, kindly come to paragraph 4. I am reading, my lord. Despite this, we cannot help but state in absolute terms that it is not appropriate for the High Court to entertain writ petition under 227, and we are sitting under 227, my lord. 227 of Constitution of India against the order passed by the Commission. And a statutory appeal, that is under 19, is provided and lies to this court under the provision of Consumer Protection Act. 1. The legislator has provided for a statutory appeal to a higher court. It cannot be proper exercise of jurisdiction to permit the party to bypass the statutory appeal to such higher court and entertain petition in exercise of its power under 226 of the Constitution of India. Here, my lord, we are in 227. Even in the present case, the High Court has not exercised its jurisdiction in accordance with law. Now, my lord, the very important paragraph, that is paragraph 9 of this judgment. My lord, in this paragraph, the Supreme Court under Article 141 has issued a direction of caution upon all High Courts subordinate to it. But while declining to interfere in the present special leave petition preferred against the order passed by the High Court in exercise of its extraordinary jurisdiction under 226 of the Constitution of India, we hereby make it clear, that is the main observation, that the order of commission are incapable of being questioned under this jurisdiction of the High Court as a statutory appeal. As statutory appeal in terms of section 27A1C lies to this court. Here, my lord, 19 and 21B. My lord, kindly speak on the judgment, my lord. My lord, kindly speak on the judgment. Kindly, my lord, I am giving so much pain, my lord. I understand, my lord. Paragraph 9, my lord.
I've gone through it. Before you, I've completed the reading of this thing, para 9.
Yes, my lord. Therefore, we have no hesitation in issuing a direction of caution that it will not be a proper exercise of jurisdiction by the High Court to entertain writ petition against such order of commission. We are in 227. Now, my lord, come to the next judgment. That is the National Insurance Company Limited judgment. The judgment has been passed by the Honorable Senior Most Judge of this Honorable Court, His Lordship Denwar, and Lordship is now as a Chief Justice, performing as a Chief Justice of Bombay High Court.
To the point, you please come to
My
the
lord. My lord, I am referring, my lord, referring 2014.
just
volume.
relevant paragraph.
My lord, actually, my lord, I am referring because of my helping my learned brother, master. Otherwise, he will shout. 2014 CHN case 57, National Insurance Company Limited. Here is the same thing happened. The order of the State Commission has been entertained by this court. Now, my lord, my lord, what have submitted earlier by my learned senior, that yes, there is a judgment of L. Chandra Kumar, the basic structure stated therein. But so, these honorable courts are differ, but my lord, these honorable courts bound to obey the order passed by the Honorable Supreme Court under 141. Now, paragraph 4 of the judgment. Paragraph 4.
Yes.
In the event, my lord, this honorable court though disagree, but bound by the order of the what I said in earlier order. In any event, I find paragraph 4. In any event, I find no reason to entertain this writ petition. The order dated such and such would have been carried by the petitioner in appeal before the National Consumer Dispute Resolution Commission. In view of the provision contained in section 19, which I refer. Paragraph 5. In a decision of the recent origin reported in 2012 Sicily Calcutta, what I have just submitted, showed my lord. That is the my lord. Paragraph 6 has been quoted in, and paragraph 6 is the observation of this court. Copy of this decision was circulated amongst the judges of all the high courts in the country in terms of the direction contained in paragraph 10 of the report. Since it is the view of the Supreme Court that an order of National Commission is incapable of being questioned in the writ petition of this High Court under 226 of the Constitution as a statutory appeal in terms of section 27(1) she lies before the Supreme Court, and what if would not be proper to exercise jurisdiction of the High Court, such and such. My lord, kindly come to paragraph 12. Be that as it may, the decision in Sicily Carolaccal is the latest judgment on the point, and even if I do not agree with the reason given therein, I am bound by section 140. Here would be, my lord, it is article. Bound by section 141 of the Constitution of India to abide by it.
Yes.
So don't disagree this honorable court, but this honorable court bound by article 141. Next judgment, my lord, last judgment is Shalini Shyam Shetty. The judgment already relied upon by my learned senior. Paragraph, my lord, 40. Kindly, my lord, come paragraph 40. My lord, got?
Yes.
I would rely, my lord, kindly know, I would rely of this judgment, paragraph number 40, 44 and 49, C, 8 and N.
CE.
Paragraph 40, paragraph 44, paragraph 49, C, 8 and N.
1 second. Paragraph 40, 44 and
49, C,
45. E.
49, C,
There is no C. C. Yes. And
C, H and N.
C, H and N.
And N. My lord, I am relying, first of all, I am reading paragraph 40.
Which judgment? Kindly give the reference. Kindly give the reference.
এটা আপনি সাবমিট করেছেন ওই শালিনী শ্যাম শেট্টি, আপনারই লাস্ট জাজমেন্ট
2010 volume 8.
2010 volume 8. My lord, I am reading paragraph 40. Same principle has been followed. Here, my lord, a direction that my learned senior friend has already stated. Yes,
I will
there
read.
is certain direction. My lord,
I will read it.
my lord, my lord. Okay, my lord, my lord, do not want to take. My lord, kindly consider that. Now, my lord, I would try to satisfy my lord. My lord, before that, my lord, I should deal with the judgment referred by the.
Now I have
My lord, may I submit, my lord? Before that, I have to deal with the judgment cited by the my learned friend. All these judgments are actually different.
Then you take time. It's already 1:30.
Because
Because
kindly take it up to.
matter is very small. Whether you discuss is or not, I will go
My
through
lord, it cannot be, my lord. It cannot be, my lord. My lord, kindly allow me. Otherwise, it would be injustice to my client, my lord.
No,
My lord, kindly, my lord.
I have followed what you have what you intend to say, what we intend to say. Everything up.
It is my belief that I will get opportunity of hearing this from my lord. It is my belief from this honorable court, my lord.
You will get the order by tonight only because I've understood. I've gone through all this thing.
My lord, these all the judgments relied upon by the.
Just show me whatever. Maybe you just show me whether how come this employee cannot be a consumer.
Okay. My lord, I am showing, my lord, that
Because
opposite party is a consumer.
he is claiming
Now, my lord,
consumer. You says he is not a consumer.
Yes, I am saying,
Power supply on payment of money, then automatically.
my lord, I am saying, and I will rely on pages from the petition itself of the petitioner.
Is he
My
paying?
lord, I am showing. My lord, in this matter, my lord,
Here all of you. Because already 1:30. यहाँ पे हम 12 बजे तक रहेंगे तो आप लोग मेरे को छोड़ेगा नहीं.
Translated copy, my lord. So there was a urgency, my lord, in the matter. I'm here to supply the translated copy pursuant to my lord. It is appearing on 28th, my lord. Board.
20th, what can I do? 20th, I will be not here. Who will pass the order?
My lord, there was a direction on the my
Then you give it.
I'll give the
You give. Then after.
Grateful.